And simultaneously, he holds several very prestigious and senior positions, such as Professorial Fellow at the Melbourne Law School, Centennial Professor at the London School of Economics. He has been also a visiting professor with New York University, University of Cambridge, University of Utrecht, in Netherlands, Columbia University, University of São Paulo, University of Toronto, and Universities of Paris. Part of the Finnish diplomatic service from 1978 to 1994, and also the international law from 2006. Among his publications are From Apology to Utopia, of international legal argument, actually a book which I remember when I wrote my PhD back in King's College London at that time. I was referring to that book, Martti. And definitely one very well known, The Gentle Civilizer of Nations, The Rise and Fall of International Law, covering a century of development since 1870 till 1960, from 2001, Politics of International Law 2011, the Cambridge Companion to International Law 2012, co-edited with Professor James Crawford, by the way, who was also our guest speaker recently. And we are very privileged and happy to welcome Martti Koskenniemi today in an online mode, but hopefully one day, once the travel resumes, we can have Martti with us in presence in Gentle Global Law School. Thank you once again for your commitment and time, Martti. And the format is you go for as long as you want to talk, take as much time as you need. The usual time of everything together is 90 minutes, and I'm sure there will be questions from our faculty and students in the audience. Once again, thank you for your commitment and time. We will all be listening very carefully to what you are going to say, and we will engage with you in the discussion.
So, okay. Yes, the slides are visible, sir, I hope.
Yes, the slides are visible to me. And I suppose I can manipulate them from my computer. So, really visible. They are visible.
You can manipulate the slides, thoughts, ideas, everything.
I think this time it's just the slides.
Let me also acknowledge Professor's latest book, The Uttermost Parts of the Earth. We are thankful, and there it is, wonderful. My copy is on the way.
Yes, I got my copies only 2 days ago, so it took a long time. Anyway, so I'm really glad I'm here, and I'm glad that we've been able to overcome these technical difficulties, which always precede a lecture given abroad, even when the lecture is given from home as distant lecture towards abroad. Anyway, so in these 3/4 of an hour, I will be speaking of the main topic of this new book, which tries to bring together sovereignty and property, which suggests that the way in which Europeans have ruled the international world is always been a particular combination of sovereignty and property. My starting point is that usual histories of international law in the past tended to emphasize diplomatic relations, diplomatic law, the laws of war and peace, and interaction between states. Moments such as the Peace of Westphalia, the European event of 1648, were regarded as quite crucial for international law because it laid out the way in which states started to collaborate with each other on the basis, as it was assumed, of sovereign equality. I published a few years ago As it was mentioned kindly a moment ago, I published a few years ago the book called A Gentle Civilizer of Nations, which was a history of modern international law starting from 1870. So the argument of that book was that international law, as we know it from the 20th and the 21st century, isn't an old thing at all. That it is a new thing. It's a thing that emerged at the end of the 19th century together with European ideas about liberalism in Europe and civilization of the colonies. It was always a specifically colonialist and an imperialist venture in the Victorian vein. Many people reacted to that argument with sympathy, but they felt that, well, what then about Grotius and Vattel and the Spanish scholastics and all those earlier people? And so I've now been trying to respond to that question. It has been usual to read the history of international law as a history of sovereignty. But when I started to study the materials, I bumped into materials like this. This is the text from the charter of the Virginia Company, the company that was set up by King James I of England to colonize an area of Virginia, and especially to set down the so-called Jamestown colony. And the king, under the context of his prerogative, donated this area to the company. And in the donation, the king said that the land, of course, a land which he hadn't seen, which none of the company men had seen, which few Europeans had seen earlier on, he donated it, all the lands in such a way that he shall hold them as of us, our heirs and successors, as our manor of East Greenwich in the county of Kent, in free and common socage only, and not in capite. So I admit that when I first came to this text, I didn't know what to make of it. I couldn't understand any of it. What is the meaning of this? It was only after some time that I realized that what is happening here is that the King of England establishes the colony of Virginia in the same way as the manor of East Greenwich was established in the county of Kent, and that the powers of the Virginia Company are the same as those of the Lord of the manor of East Greenwich. And the powers of the Lord of the Manor in East Greenwich at the time, in the early 17th century, were the widest possible powers through which you could control a territory. This is, of course, a deeply feudal arrangement. Within feudalism, ownership of land was divided always in two. There was the so-called dominium directum, which belonged to the ruler of the realm, the king or the queen, the sovereign, if you wish, although sovereign, the vocabulary of sovereign is inappropriate when we speak about feudal relations, suzerain, and all the concrete rights, the rights to use the territory, to enjoy its fruit, etc., was dominum utile, which belonged to the actual holder, concrete holder of the land. And so here, the King of England imagines America in terms of a wide set of rights of utilization, while overlordship remains with him. Now, this isn't either sovereignty or property. This is something else. It is a mixture of the two things. And what I'm going to suggest to you in the course of this lecture, that European power has always come as a mixture of the two things. And it's just the distortions of legal doctrine that have separated from each other these two ways of power, namely property and sovereignty. But one has to start from the beginning. I already said that in the feudal period, the period also of the English colonization, both the word dominium, the Latin expression dominium, played a huge role. And in order to understand dominium, we have to go to the Bible. And dominium actually exists at the very beginning of creation. Here is a famous statement from the Genesis, from the story about the creation of the world. And the Bible tells Christians that there was a moment during creation when God said, "Let us make mankind in our image, in our likeness, so that they may rule over the fish in the sea." And the word there in the Latin translation is dominium, to rule over the fish in the sea and the birds in the sky, over livestock and all wild animals and all wild creatures that move along the ground. So there is in Christian ideology, there is a very strong sense that human beings have things as dominion, that God created the world and donated it to us. This idea was then used in the 16th century in the context of the Spanish scholasticism. In the early 16th century, Spain was part of the Habsburg Empire. The Habsburg Empire pretended that it was a part of the universal empire of Rome, that the emperor himself was, as Roman law puts it, dominus mundi, that is to say, the ruler of the world. Now, of course, in the 16th century, the Habsburg rulers, Charles V in particular, did not quite take that seriously, but his lawyers did. All those lawyers were educated in Roman law, and they viewed the king, and in this case, the king of the Holy Roman Empire, of the Roman nation, as ruler of the world. Charles V was the Habsburg king that ruled the greatest part of Europe, as well as, of course, carried out the conquest of the Indies. In the period, the most important intellectuals of the empire resided in Salamanca, in Spain. They were Dominican theologians. Francisco de Vitoria is the one whom we know very well from that time. And he took the notion of dominium, which unites a Roman law idea of rulership as well as ownership, and the idea of dominion from the Bible, which justifies the rulership and the ownership of human beings through the idea of God's donation of it to us. The Spanish scholastics are extremely important in the story of the early development of international law, because they were the intellectuals who explained to European Christians how it was possible for the emperor to claim to rule over Indians in the Indies, although those Indians had never seen Spaniards, had never been officially made subjects of the Spaniards. And Vitoria explained that the ruler ruled over the Indians because they were humans and because the ruler himself had occupied the lands that they owned, and the Roman law governed those lands like it governed the rest of the imperial territory. But he also, at the same time, saw around himself, Vitoria saw around himself not only the conquest as something that needed justification, but also the extremely wide expansion of trade that was to a great extent made possible by the conquest itself, and especially by the imports of silver from the mines of Potosi and elsewhere in Peru, Colombia, New Mexico, in the Indies, that as it has been said, oiled the wheels of commerce in Europe and China and elsewhere. With the expansion of trade, however, a new ethic, a commercial ethic, emerged, which threatened Christian values. So there were two sets of ideas that in the early 16th century needed justification. On the one hand, the claim of jurisdiction made by the king, by the emperor, and the claim of property rights made by people who occupied territory or owned movable goods and indeed participated in commercial transactions. And so the 16th century scholastics took this one idea, dominium, and divided it into two, dominium jurisdictionis and dominium proprietatis. These two ideas represent dominium in its two forms, the power of the ruler over his subjects and the power of the owner over everyone else to exclude those others from the things that the owner owns. By using the notion of dominium, which had both a Roman law content and a Christian content taken from the Bible, the Spanish scholastics were able to justify both the claim of jurisdiction made by the king over the Indies, as well as the claim of property rights made by Spanish exchanged professionals, Spanish merchants, and European merchants in general. The idea of dominium then, like much else of what the Spanish Dominicans of the early 16th century were doing, was then taken over by the Dutch Protestant Hugo Grotius. Grotius is of course known of his main work, De Jure Belli ac Pacis, on the laws of war and peace, which was published a century later than the Spanish scholastics, namely 1625. Grotius too was involved in a colonial enterprise, the Dutch Republic, the 7 rebellious republics that had just separated themselves from the Habsburg Empire, were busily colonizing East Indies. They were setting factories and small trading posts all around the East Indies islands and also the Indian Peninsula, and were claiming property rights over the goods and the production chains, as we would say today, that led to spices being delivered to Dutch vessels in the East Indies. However, the Dutch in their colonization venture were waged in a war against Spain and Portugal. I said a moment ago that the Dutch Republic was a rebellious republic. It had earlier on been part of the Habsburg Empire, but because of religious and economic disputes, they had separated and they were in war against their former emperor, the King of Spain, the Emperor, the Holy Roman Emperor, and in particular Portugal, which then was at the time, or became at the time, a part of 1580, the part of the Spanish Empire. The Portuguese were claiming monopoly rights to trade in the East Indies, but the Dutch didn't care. The Dutch actually were efficient marines and quite extensively were able to occupy the colonial trade links previously held by the Portuguese. They did that by reference to their right to do that. Grotius is known of having written another large work, De Jure Praedae, which has been recently republished as on the law of booty, of prize and booty, which is the advocacy work that he wrote on behalf of the Dutch East India Company in a legal case in Amsterdam. I don't have the time to go to the details, but this legal case had to do with the legality of the Dutch capture of a Portuguese vessel in the course of the Dutch war effort, and the question to whom did the cargo of the vessel belong. And Grotius argued there that it belonged to the Dutch because the Portuguese had violated the rights of the Dutch to the Indies. Therefore, they were entitled to wage war against the Portuguese as well as capture Portuguese cargoes. So that was the early work, De Jure Praedae, on the right of prize and booty, which was never published during Grotius' life. It was an advocacy brief to Amsterdam Admiralty Court. But indeed, in his main work, he comes back to this idea of right. And actually, he lays out 3 different notions of right, of which he then chooses for the whole of his work 1. Out of these 3 concepts of rights, he first lays out right as the objective of just action. So when we act justly, then our objective is to create a condition of rightfulness. So that's one understanding. It's an understanding that comes from St. Thomas Aquinas. It's an understanding that exists in the Spanish scholastics. It's also a Christian understanding, but it's not one that Grotius really almost ever uses, only sometimes. Then he says there's another notion of right, or use, as he uses the Latin phrase, namely the same as law or a legal enactment. Something is a use when it is a legal enactment by the king, by a parliament, etc. But he very rarely refers to that either. So he mostly refers to throughout his main work, which in a sense provides a full-scale vocabulary for international legal relations from the early 17th century onwards. He uses throughout that book a third notion of right, and that is the notion that I have depicted here, namely use as or right as a moral quality annexed to the person, enabling him to have or to do something justly. This is the notion of subjective right. This is the notion that every individual enjoys from the day of his birth. And throughout De Jure Belli Ac Pacis, every law, every legal system, every legal idea, almost, let's say 95% of it, has to do with subjective rights or the protection of subjective rights. A just war is a war that is made in response to a violation of a subjective right. Now, it's this idea of the subjective right that underlies both Dutch imperial power as well as British imperial power. And I have here taken a book from the customs documentation held by the British Levant Company. In the early 17th century, the Dutch, of course, had set up their East India Company, but so had the British. And they had charged those companies with doing a lot of administrative work. Here is a page from the customs book, as I said, from the Levant Company. The Levant Company was outsourced by Britain to carry out customs surveillance and customs reporting. For example, just as one example of the various kinds of activities that we would today think of as belonging to the sovereign. Here now they belong to a company which exercises them by reference to their private rights. At the same time, France started its colonial venturing. Cardinal Richelieu appointed himself Grand Maître de la Navigation, that is to say, the master of navigation in France. And in the course of the 17th century and way into the 18th century, France carried out almost all of its colonial activities by reference to private companies who operated precisely in the feudal fashion that I tried to canvass earlier when I spoke about the Virginia Company. That is to say, the company is the concrete operator in the territory enjoying what in feudalism was understood dominium utile, whilst the king preserves to himself the overriding right, the right of faith and superordinance or suzerainty, as they say. I have dotted here the name and the image of the most famous of the French private colonizers, the financial expert, the banker, and one of the greatest financiers of Louis XIV, Antoine Crozat, who received a large part of Louisiana, or a large part of the French colonial territory in Northern America as his private fief. He never was able to get it produced in the same way as the English, but he was the owner of that territory, and in the capacity of the owner of that territory was able to legislate over it. He set up jurisdictions over it. Only he could also legislate over it only with the proviso that he could not do this against French laws. Here is in French the charter of the first company, or one of the first companies that Richelieu set up, namely the company of 100 shareholders, La Compagnie de Saint Associés. Here the Majesty gives in perpetuity to the company, to the company in whole propriety, justice, and seigneury, the whole area of Quebec, which, as you know, is today a province of Canada. And at the time, the province of Canada was imagined to start in Florida and continue until the Arctic Circle. There are 2 points to note here. One is the enormous scope of this donation from the French king, from Florida to the Arctic Circle, and it's given to a private company for perpetual property, justice, and seigneury, which means that the company is entitled to legislate and to set up courts in that area. Of course, nothing came of that. But one can say the same thing about France as well. At the moment in French history that we think of as the hardest moment of statehood, when sovereignty crystallizes over France, when the Sun King is supposed to have said that the state, it is me, l'État c'est moi. One could also give a correct description of France as a conglomerate of over 50,000 office holders who hold their office in the French state as private property in such a fashion that their oldest boys are entitled to inherit those offices in the French state. All the tax collection and all the financial management of the French state at the peak of absolutism, so-called, was outsourced to tax collecting companies and to private financiers. So I make this point in order to underline what I want to say, which is that in European history, sovereignty and property are completely intertwined. A correct description of this moment in French history, for example, would be that, well, it's an absolutist country ruled by one person, and at the same time, it is an oligarchic regime ruled by a number of families with who are contract about its policies with each other. This is the time, the 18th century then, in which standard histories of international law lay out the principle of balance of power, that supposedly during the 18th century, as an outcome of the Peace of Utrecht, 1713, European states agree on a balance of power. Well, in a sense, yes, but also in a sense, no. Namely, during the 7 Years' War in the middle of the century between France and Britain, Britain is able to destroy French colonial trade because of its naval supremacy. The French argue that this is a breach of balance of power because under European rules, no country should be able to have an overwhelming maritime superiority. Maritime resources, ships, marines, colonial outposts, to the extent that they can override the sea, override everyone else. Here is now a copy of a text by a German natural lawyer hired by Prussia's Frederick II, that is to say, Frederick the Great, to look into the matter of the balance of power at sea. And here in this work called Die Chimäre des Gleichgewichts von Europa, that is to say, the chimera of balance of power of Europe, Johann Gottlob von Justi explains to his readers that it is possible on land to set up a balance of power because states are able to survey the military forces of each other and can agree about that. But it's impossible to set up a balance of trade because trading relations operate outside the politics of countries. Trade relations are dependent on the activity of businessmen all over the world. It's in the interests of every nation to allow their businessmen to be active, their merchants to set up trading posts all over the world. And it's impossible to separate or to agree on states limiting their trade relations in the way that it is possible for states to agree to limit their military armaments on land. And the punchline of Justi's work is that we have to understand that there are political relations and commercial relations. And while political relations can be agreed upon and limited by states, commercial relations are naturally free, so that every state is free to operate as it wants. And if this gives it a superior status, there is nothing that can be done to limit it. Now I have to go on a little bit more rapidly. Here are two other natural lawyers, Samuel Pufendorf and Adam Smith. Pufendorf comes up with this idea that human society is based not on the idea that Grotius put forward, namely the idea that humans are naturally peaceful and love each other, nor on the idea that humans are wolves to each other, that it's only envy and hatred that rules in human society. So both Grotius and Hobbes are wrong. So humans are sociable, but not naturally. Humans are artificially sociable. And he creates in his main work, De Jure Naturae et Gentium, this algorithm. Law is based on nature, on human nature. And human nature can be verified by reference to qualities that all humans share. What are those qualities then, Pufendorf asks, and he finds three. First of all humans are egoistic. So that sounds like Thomas Hobbes. Humans are ambitious, egoistic, and always want to attack each other. But then he says there are two other things. Humans are not only egoistic, but they are also weak. Unlike other animals who have sharp teeth and sharp claws, or who have enormous muscles with which they can defend themselves, humans cannot defend themselves. Humans are easily killed and destroyed. But then there is a third quality in all humans, which is what? Which is that humans, unlike animals, have reason. And for a person of reason, who is both egoistic and weak, it makes sense to join together, not because you love other people, but because you need them in order for yourself to survive and flourish in society. And so he creates this idea of artificial sociability. He is a follower of Grotius, so he takes this idea of subjective right as the basis of a natural law theory of artificial sociability, where all humans are naturally inclined to create friendly relations with each other, and that then is their subjective right as well. And that work then is translated a century later by Adam Smith, who himself said that he was working in the footsteps of Pufendorf and Grotius into the idea of the invisible hand in the wealth of nations. The most famous statement in that book, of course, is that it is not of the benevolence of the baker or the butcher that we receive our daily bread or our daily food, but their regard for their self-interest. So through this chain of arguments that start from the idea that God donates the world to humans, humans then create the twin ideas of dominium jurisdictionis and dominium proprietatis. They divide the grant that God gave them into rulership on the one hand and public law, and private property on the other hand, ownership, both covered by the justification that dominium expresses, that is a fundamentally theological justification. That then proceeds into this idea of private rights that entitles humans to look at themselves and to operate in self-interest, but as Pufendorf expresses it, in their reasonable self-interest that Adam Smith articulates through the theory of the invisible hand in the wealth of nations. I then say a few words about colonial government in America and in India. The government set up by these acts in America are in part governed by crown prerogative, namely when the crown enacts navigation laws to set up monopoly for trading in America, sets up the Privy Council and various commissions to rule over what happens in the colonies, and controls colonial legislation so that it's not to be repugnant to the English laws. And in the end of the British rule in America, the Parliament starts legislating there. At the same time in America itself, the companies have proprietary rights, and those rights include the right to legislate, to set up courts, to set up local assemblies, and to enjoy the ancient rights of Englishmen, namely no taxation without representation. So one can say that English colonization embodies a hand of sovereignty on the crown side. The crown has certain but very limited rights. And then on the colonial side, there are private rights that create a system of government in which public power is almost, and in some cases totally, non-existent. The East India Company, of course, operates in the same way. I don't have to go to details. Many of you know these details better than I do. In 1600, Queen Elizabeth gives a monopoly trading and jurisdiction right to this private company in the Indies. In the Restoration area, or the King James II grants to the East India Company jurisdiction over all the plantations, forts, fortifications, factories, and colonies that they have established in the Indian Peninsula. Bombay is received, as it was then, was received from the King of Portugal as a dowry by the English king, which then donated it to the East India Company with all the manorial rights, that is to say, all the rights of jurisdiction and extraction of resources, with the king preserving only faith and allegiance and sovereignty. Sovereignty, however, at this point, meaning only a limited percentage of the produce or the profits produced by the company. In the later 17th century, the monopoly is confirmed as a law of nations principle. In the famous Sandys case, the British judges in that case look at what Grotius had said, look at the practices of France and Holland, and accept private monopoly companies and their jurisdictional powers as part of the law of nations. After the Battle of Plassey, which wasn't actually much of a battle, the East India Company then contracts with the Mughal emperor to receive rights of administration and revenue in Bengal, and in the process destroys Bengal's economy and creates this terrible situation, economic and resource situation there. Only in 1813, the British legislation for the first time clearly says that sovereignty is in Britain and not in the company itself. In the 19th century, the British Imperial law in many ways interacts with private colonial actors outside Britain itself by the enacting of the Foreign Jurisdiction Act in 1843, in which the Queen herself, this is Queen Victoria, takes the power to exercise and enjoy any jurisdiction with Her Majesty now had at any time within any country or place out of His Majesty's dominion. The justification for the Foreign Jurisdiction Act was that private adventurers and traders had been wreaking havoc and acting against British interests. So the Brits only now explain that they will take jurisdiction. Lord Palmerston's famous statement to the Parliament is similar in intent. It says that according to the British Foreign Secretary, or the Foreign Secretary, the British will always protect private British merchants and other actors when they are operating outside Britain, because, as he says in this colorful language, as the Roman in days of old held himself free from indignity, when he could say, civis Romanus sum, I am a Roman subject, so also a British subject, wherever he may be, shall feel confident that the watchful eye and the strong arm of England will protect him from injustice and wrong. The Americans start out similarly by setting up the famous claims commissions having to do with revolutions and other destruction of American property in Central and South America. The US State Department imposes these claims commissions on the South American countries, and in a series of judgments, they lay out the law regarding the standard of treatment of American businessmen and American companies in areas outside the United States. Now the history comes to an end. In the late 20th century, sovereignty does migrate also into the South. Decolonization makes it possible for a number of formerly colonial countries to become formally independent. At the same time, properties migrate to the North. And the present international economic system is created whereby it may be true that the formerly colonial powers now have permanent sovereignty over natural resources, but a situation has been created where they contract all the exploitation of those natural resources to foreign companies, and where the system of exploitation is protected by the system of investment protection. And what is the system of investment protection? Here is a statement from one ICSID investment tribunal in a case Inmaris versus the Republic of Ukraine, which I think in a nutshell demonstrates the understanding of international law today of the relations of political or sovereign power and private power. This is a quote. Of course, under the investment treaties, under the investment system, a state is called upon to protect the foreign investor and should not take any action that encroaches on the profits of that foreign investor. And in this case, the foreign investor Inmaris has argued that the state of Ukraine has indeed encroached on Inmaris's profits, and in an obiter dicta, the investment tribunal says this: a government act could be unfair or inequitable if it's in breach of specific commitments, if it is undertaken for political reasons or other improper motives, if the investor is not treated in an objective, even-handed, unbiased, and transparent way. What is interesting in this statement is that political reasons, which are reasons of sovereignty, are improper motives for a state to apply when it deals with a foreign investor. Now, of course, the investment system today is widely challenged, and I wanted to merely mention it here so as to illustrate the way in which the conflict or the situation between sovereignty and property still today exists pretty much in the way that it always did. And so I end with this, namely that it appears that in this long history that leads from Cicero, here speaking in front of the Roman Senate, to the foreign investors and stock exchange operators of today, there are two styles of government. And those two styles of government have constantly underlined the history of international law, especially the history of international law when we look at the relations between Europe and the colonies, but also and equally in Europe when we look at what it has been that has made it possible for European sovereigns to exist. So, and I end with this punchline. So here is my punchline. Sovereignty and property are the yin and yang of European power. They are constantly intertwined and come to us constantly together. So that once you see sovereignty somewhere, it's useful to scratch the surface so as to see property operating behind. And when you see property somewhere, it's useful to scratch the surface so that you get the aspect of sovereignty, the police, the military force visible. So I end there. I thank you very much, and I'm now open for discussion.
Well, wonderful. Thank you so much, Martti. I think nobody else can put together in so short time, over 50 minutes, the Bible, the Roman law, the emperors, the various empires, the colonization, the decolonization, the subjective rights, dominions, political limitations, commercial freedom, and so many excellent references to the history of political philosophy and international. So absolutely amazing. Well, after such a voyage in history, it's not easy really to formulate a question, but let me just say at one point I experienced something similar, this connection between sovereignty and poverty when we discussed the humanitarian intervention and responsibility to protect. It was back 23 years ago in the Yugoslav conflicts, the Kosovo intervention, and the discussion that followed after that by an International Commission on Sovereignty and International Intervention, producing the concept of responsibility to protect, and somehow trying to reconcile the idea of sovereignty with the idea of responsibility. Yes. In other words, the argument was made, rightly or wrongly, that sovereignty doesn't come from divine source. It's not God-given. Sovereignty is a responsibility to people. Something what you also mentioned in terms of moral, the third moral duty that every individual have the rights to enjoy. The subjective rights is also very much strongly emphasized in all those centuries of developments, including by the judgment you mentioned and the kings who also always pretended, even if they did not, they pretended they act on behalf of the subjects. And for that matter, attempt was made. Again, I'm not saying it was a successful one, but I'm saying that at least an attempt was made to argue that there couldn't be unlimited and absolute sovereignty. Rather, the sovereignty should be qualified with the responsibility to the subjects. So people do matter, and a tyrant, dictator, cannot simply claim sovereignty if he or she does not protect the populations, and therefore responsibility to protect as part of the sovereignty. So in other words, here we come to a statement that in a sense, intervention and sovereignty are not really opposite. You can still make an argument for intervention to protect people as a sovereign right, as a sovereign claim. So the sovereignty belongs to people. It doesn't belong to God. It doesn't belong to a king. It belongs to a people, and people can claim sovereign right and the right of life, the right to be protected, and the rest of the human rights. As you also mentioned, and I kind of connect this to what you said about no taxation without representation. You cannot tax people without representing people, which I also find interesting. I also find that there is something there as well. So if you want a question, then I will ask, is there something in early ages which also suggests that sovereignty cannot be unlimited? It needs to reflect the expectations of the subjects. It's not something that the Commission created 20 years ago. The responsibility was there always, to a certain extent, even if it was not explicitly written in law.
Every absolutist ruler has always said that the absolutism of his rule is needed because otherwise the state will collapse, otherwise the community will be engaged in civil war. So Alberico Gentili, who was this early international lawyer in England, the Regius Professor of International Law in the 16th century, was also a very strong supporter of absolutism. And in his lectures and in his published works, Regales Disputationes, he makes a powerful point to the extent that if the king doesn't rule in an absolute way, if it is allowed to challenge the king, then this will just lead to more and more dissension and finally into the civil war. In the 17th century, he was, of course, followed by Thomas Hobbes. And the Hobbesian idea of absolutist rulership is based on precisely this idea, this nexus of protection obedience. So citizens have a duty to obey if the ruler can protect them, and the other way around. The ruler can claim the duty of obedience if he is able to protect them. Throughout history, the very justification of sovereignty has been the idea that the people need protection. Now, of course, this has been said by ruthless tyrants over and over again. But it's the fact that they say it, it doesn't mean that it's wrong. It does say that it's that there is no pre-given content to sovereign powers, and that sovereign powers are constantly negotiated, if you wish, in a political struggle between the ruler who wants to have as wide powers as possible and the populace who wants the ruler to have so wide powers that they are actually protected. If you go to Afghanistan today and you ask the women there, what is the most important right that you have? They would say, well, the right would be to protect us from the Taliban, damn it. And maybe that would be possible only by setting up a really good king who is able to get rid of the Taliban. This is all, of course, just conceptual and not real. The point I am making is that sovereignty and protection have always been indissociably joined together, and that the political debate has always been about, well, what is actually needed for protection and who is it that needs that protection? And people disagree on that. People are wary of each other. Thomas Hobbes, whose final solution regarding absolutism we may not appreciate, was nevertheless a very sharp-sighted analyst of human society. And his view that humans are wolves to each other, that in a natural world, life is nasty, brutish, and short. And that in order to prevent nastiness, brutishness, and the unending killing, you need a strong power somewhere. And then, of course, there are always many candidates for that strong power. And it is up for political debate, or let's say political struggle between those candidates for power to try to find their way to the seat of sovereignty and then to rule in a way that people actually are protected.
But do you agree with that? Sorry, there is another point of view here. Obviously, we know Hobbes, we know Ayn Rand, the selfish, the natural wolves. Humans are evil naturally, and we need a power to control them. But like Rutger Bregman, this young Dutch philosopher, in his book Humankind, A Hopeful History, actually makes the opposite argument. He said this was a creation. It was an artificial creation that humans are evil, and it was made as for the powers to be stronger. So somehow it empowers the strong, and it basically makes the rest of the population obedient. But he studied and he went into the history of wars, how difficult it was for soldiers to kill other soldiers. And he found that only 20% of the soldiers actually did kill other soldiers. The rest denied to do that. They were only helping the war rather than actively shooting an enemy soldiers. So it is not pleasant for the humankind to kill someone else, he argues, and therefore the good part of the human nature is the leading and the original and the initial. So humankind, he argues, again, I'm not saying he's right or wrong, but there is another argument, anti-Hobbes argument, that in fact, humans do cooperate. And again, he gives many examples of people left in an island and after a shipbreak, and these children there didn't fight each other rather than cooperate to survive. So and John Locke, yes, my friend, is also helping me with another argument. So did that selfishness and evil nature of humans was kind of artificially created? It is probably somewhere in the middle, I guess. We have a history of conflicts and history of cooperations. Humans did survive because they cooperated, as many historians did argue. But for that matter, let me also bring you another comparison here, the domestic and the international law. In domestic constitutional systems, it's a very clear relationship between the ruler and the ruled. So we have the responsibility of the government and the rights of the people, and it is very well established as institutional separation, the executive, the judiciary, and the legislative power. But none of those somehow correspond to international law, where we have, let's say, United Nations organs, the General Assembly, Security Council, and International Court of Justice, do not really act as legislator, executive, and judiciary. And we shouldn't probably try to argue that international law does the same function as domestic law, establishing that relationship between the subjects and the government. Because states do not act as citizens, they feel sovereign, they feel empowered, and they don't feel the obligation to follow rules when they don't need to. So where do we link here international law? So if you make the argument, which is very clear in domestic systems, sovereignty and property, the reflection of the separation of power, relationship, rights and responsibility of the sovereign and the subjects. In international law, that picture is very confused, I must say.
So there are two questions. One is, about human good and evil, and the other one is about the so-called domestic analogy. Is there a good point to make the domestic analogy? So let me go to good and evil first. So of course, so this is a deeply philosophical and religious question, and I can't pretend to answer it in any specific way. Let me just say, as a historian of law, that when the Spanish scholastics in the 16th century looked around themselves and they saw the things that they saw, the conquest and the killing of the Inca king Atahualpa, when they saw what the conquistadors were doing, massacring Indians, and when they saw what Europeans were doing to each other in Europe. The king of Spain, that is to say the emperor, was in constant war with the Bourbons, so the Franco-Spanish opposition, the Protestant rebellion was was going on in Germany, and war continued there. When they looked at all of that, they felt that the teaching of Christ, namely that humans have the ability to be good, is not sufficient, and that we need these bounds of jurisdiction and property to deal with the problems that emerge in the real world. These were theologians. They were religiously committed and doctrinally committed to thinking that humans were made in the image of God, which can only mean that humans are good. And nevertheless, they see this unending bloodshed. And we've seen all of this bloodshed from that period to the present. So that for people who think that the human is created good, it's a really big problem as to how do you deal with the real human being. And people then like Thomas Hobbes and Grotius too, and Gentili, people who were supporting absolutism, were very aware of the fact that the real human was very different from the Christian image of the human being made in the image of God. And they didn't support absolutism because they were evil or stupid or didn't understand human nature. On the contrary, we appreciate them because they saw this tragedy at the heart of human being, that although we desire good, we somehow constantly end up doing evil things to each other. We need structures that prevent us from going the bad way. I mentioned earlier Samuel Pufendorf, a follower of Grotius, and Pufendorf came up with this idea of artificial sociability. So his argument was, and this was the argument of Adam Smith, and this is the argument of capitalism, that it is not true, well, that we cannot rely upon the assumption that humans will be good to each other and will do beneficial things to each other. We cannot rely on that. And therefore we have to think about how we should then live and in a situation where we cannot rely on that. And the response of Pufendorf and Adam Smith and capitalism has been, well, if you reason about it, then you, whether you're good or evil, you benefit from cooperating with others. Cooperation is in your own interests, you egoistic individual as you are. And the Western way of life is based on that idea. It tries to take a step away from the Christian assumption of human goodness and to deal with problems in society as they are by assuming that even evil people can understand that they must cooperate so as to survive. So that's one way. So let me just leave it at that. That's my response to the first question. The second question is, well, yes, ever since 20th century, so modern international law began, which I date from 1873 and the establishment of the Institut de Droit International, etc. We don't have to go there. But anyway, so when modern professional international law started and got going in the 20th century, when the League of Nations was established, when the United Nations was established, and its very many specialized agencies, most international lawyers have either consciously or subconsciously thought in terms of the domestic analogy, that the rule of law in the international world in some way, may be difficult, but in some way must be made to resemble the domestic, so that there must be some place where laws are made, that legislation, that there must be some place where the implementation of laws is administered, so administration, and there must be somewhere where courts decide on the colliding rights of legal subjects. And many people have quite expressly in their textbooks or in the first lectures to first-year students have said that, well, the UN General Assembly, is not really a legislator, but it looks a little bit like one. And the Security Council is not really a government, but it does, it has the powers of enforcement and so on. And the International Court of Justice and the International Criminal Court, they are not really a court like a domestic one, but they look like it. And so, and that idea, the domestic analogy, is usually based on a Kantian presupposition behind it, that we can think in these terms because these terms exist in a historical trajectory, so that we don't have that thing. The international world isn't operating like the domestic quite yet, but that in some years, maybe decades, perhaps centuries, that is the way in which historical progress points. There's very little evidence that this is the way that history has these kinds of regularities. But this is the way international lawyers think, and I'm agnostic about whether or not there's any sense in thinking like that.
Very well said. I absolutely agree, Martti, on both answers. And if you remember, the idea that it is really a humanitarian intervention has always been questioned exactly as whether it's not about good or evil. And often selfish intervention can serve humanitarian purposes, but it's not because the interveners were humanitarian. They didn't care about the people there. They simply intervened because of selfish national interest, often projected as humanitarian interest. And even some at the time argue, Stanley Hoffman and others, that we don't need to worry if the intervention is really selfish or humanitarian. It should be serving the purpose. So it's kind of a utilitarian approach. If it does do the work, it doesn't matter what are the morals or the motivations. Absolutely amazing. I agree with both your answers, and I will leave you in the hands of my students now. Thank you very much, Martti. Ankit, would you want to moderate?
Yes, well, let me first begin by thanking Professor for the most riveting talk. How we can do this is we can take questions as and when they come, but I'll just ask the first one and request others to share their questions either live or in the chat box. Just following with the discussion, what I've read about is there is this section of divinity which is also attached with rule, that the rule which you have is a calling from God, or is rather a divine rule which you exercise. And to that front, since Lord Palmerston was mentioned, I recollect a quote which I counted of his was states have no friends, only interests. And I think that seems quite central to the thesis of Professor Koskenniemi's presentation. I equate this with, since Professor ended with a punchline, I recollect reading punchlines and jabs really in writings of one Michel Foucault, and what Foucault really talks about in the context of power, and I sort of relate that to the Panopticon. And this mission of the Panopticon really represents, at least in my understanding, the colonial project. And the center, which is the Panopticon, sits the empire, but the Panopticon's surrounding circumstances, or the means which it regulates, is something which I found reference in writing of one Edward Said, who talks about Orientalism, and I refer to one of writings which I had used his work on, and he says, and I quote, "From the beginning of Western speculation about the Orient, the one thing the Orient could not do away was represent itself. Evidence of the Orient was credible only after it had passed through the refining fire of Orientalist work." Said explained how colonialism works. According to him, the colonial project is not limited to a war fought between armies. Rather, Said contends the colonial project seeps into every crevice of society, its art, literature, humanities, and social sciences. A narrative is spun, a picture of the East is sketched. Snake charmers, belly dancers, and thieves. The exotic, the sensual, and the depraved. To this explanation of the empire, I seek Professor's comments and understanding of at least how I understand empire, and not essentially in a bad light, but as a critical analysis of what was imagined and envisaged.
I completely agree with what Edward Said says there. And Dipesh Chakrabarty has also, in an interesting way, reflected on the fact that the colonial world cannot be represented in itself, that it is always represented through a Western interpretation or a Western understanding. I have recently come across this problem when I've been thinking about how post-colonial international legal scholars, what attitude they should take to working in the vernacular of international law. Because if that is what you do, so one has to remember that the world as we have it is in part a creation of international law. International legal arguments, ideas about sovereignty and property, and so on. And when the first generation of post-colonial scholars came about, P.S. Anand from India, for example, Taslim Elias from Nigeria, those people whom in the 60s and 70s, they started to write books and articles, present themselves in the UN meetings and in the International Court of Justice. They used this European vocabulary of international law and relations. And that was a problematic choice for them, because in a sense, they were saying over and over again that we must be represented because we too have these words. We too have diplomatic relations. We too have had immunities. We too have had laws of war, etc. And constantly having to say that as it were, we too are Europeans. And I think the third world approaches to international law more recently have taken a distance towards that idea and no longer so confidently speak in the vernacular of international law itself, because it seems to be a prison house. You speak in the language of the oppressor, if you wish, the language of the colonizer, and the language of the colonizer, every feature of that language, every feature of the institutions that the colonizer has created are intended to perpetuate colonial relationships that, as Said says, are not just relationships between the geographic north and south, but are human relationships that operate at every level in which human relationships operate. So I put this to you as a problem. Is there an alternative? You can't just invent and believe that anybody will take you seriously if you start to think in terms of other institutions, other vocabularies.
And just to echo that point, it's not actually the approach, but what is offered as an alternate in the form of a third world understanding. And I quote, we're hosting Professor Balakrishnan Rajagopal and I beg your pardon, Professor Chimney on Twail and its relevance. So to prepare for that, I encountered a writing by Jose Alvarez, who in fact launched this society. And Alvarez is rather critical of Twail. He writes, and I quote, and perhaps this will ring more closely to you because he mentions it in such a language. He says, Twail would mean using the world's foremost hegemonic institution, subject to a voting system and membership that owes much to colonialism and notions of cultural superiority, in defense of the judicial rulings of another flawed treaty-based institution, whose very raison d'etre is grounded in concepts of transitional justice that owe a great deal to Twail's despised civilizing mission. So the Twail perspective seems rather limited and skewed to understanding international actions from a very parochial vision. They would see the NATO intervention in Belgrade as an intervention of sovereignty, whereas in the West it was understood as a completely heroic gesture. So I seem to not come to terms with Twail and would perhaps see what professors will offer later on. But just as a comment on this, if you would like to share something, and then I'll yield to others.
Well, so I have a difficulty in thinking in terms of homogeneous blocks called Twail, Western, and so on. When we look more closely at the kinds of writings that people associated with third world approaches or European approaches or critical approaches or even feminist approaches, etc. So we find that people disagree, and it may be too easy to put them all in the same basket. I just put forward a problem, which is a problem. Can you operate with the vocabulary of international law if it is true that it is the very vocabulary that has created these unequal relationships in the world? And I'm not saying you can't. And international law, like every vocabulary, is open-ended, or as I say, indeterminate. So you can use it for a number of different purposes, and you can use it against itself. It requires a strategic eye and an ability to think clearly as to what one wants to achieve and what one wants to avoid. I don't think there's much of an alternative. Dipesh Chakrabarty in Provincializing Europe recounts his own experience as a historian of the Indian historian who wanted to write Indian in an Indian vocabulary and to get the authentic histories out. But when he then went to the archives, he found that all the archives had been created by British historians. All the past had been interpreted already by British historians, that there was no authenticity there to be found. And so the only thing that, so you could not discover a voice that no longer existed or imagine it into existence. So what he famously suggested you can do is to think about Europe as a provincial place. Think about European principles not as universal, but as really exotic and eccentric principles supported by this weird group of white-faced people living on that particular continent, peaking one bit of Asia, really. And my own work with international legal histories, when I look at the Gentle Civilizer, my idea was to bring Europe down from representing universal down to just men with projects. So that is how my friends and I have been thinking of writing these histories, not as some world historical universal story about how mankind has developed, but how some guys, some European men, with all the little wisdom and the great stupidity that they have tried to, operate in complex economic and political situations, and you may want to learn or you may want to not learn from them, whatever. And so that is available to us. And that, I think, would be something I would also counsel to Twail people as an approach to Europe. and then of course develop their own voice and develop their own stories with their own people.
Absolutely. I cannot agree more with that, Martti, because I also think that we cannot accept voices when I agree with all the history of colonization, pretended civilization, and everything stupid and bad done by the Western powers to the colonies. But on another hand, to say that human rights, rule of law, democracies are Western intervention in our way of life, I also don't accept that. To the point that these are not really Western values. All
see, I don't think in terms of values. I think
human rights are
universal.
There are origin in democracy and human rights everywhere in the world, in Iran, in India, in Africa, and everywhere else. They may have different names and different vocabulary, but they do exist. So what I would like to see is not to reject universal values because of colonialism and Western intervention, but rather to voice local interpretation of all these values and rights historically, instead of simply condemning the West of intervention and imposing certain values, to identify original Asian and African and American values and to say these are our vocabularies. That's how our history brought us here. It's not Western, it's not even local, it's universal. And I see universality not so much as everybody agree with everything, rather in the other way. The local voices, historical, should come and say, what we created is our own, it's identical, it's unique. And then when we are happy with all those values, then they are universal because of origin. They exist in every village around the world. That's why they are universal. They are not universal because in 1948, Eleanor Roosevelt and some Canadians and French wrote it down. They are universal because centuries ago, in every part of the world, those values did develop in every society.
Professor, I had
just have Professor make a comment which he was making, Vice Professor Popovski was speaking on values.
Well, yeah, so I think a little bit differently. A couple of short things because we have to end very soon. One is, I don't think the universal has any authentic representative of its own. Everybody thinks that they, in some ways, represent something that's universal. And to bring universal into the conversation is always dubious, because you want to say you speak in some language that is bigger than you. And I don't think you have the authority to do that. We all speak in our own voices and our own histories and our own wisdom and stupidity. So for me, to reference universality is meaningless. And the second thing is that values, the talk about values in the world is really problematic. And I don't know what values are and how you verify values and where can they be found, under the table or in the closet. Where is a value? What is it? So I just hear this language. I hear this talk, this endless talk, and therefore and everybody can talk the talk. As an analyst, as an historian, I've never thought that it's my task to do anything more than to report about how people speak and then to show what they do. And looking behind as to whether there are some values or needs or aspirations, etc. Of course, there are such, but I can't verify them. And I think very often speaking about them tends to be meaningless. It is trying to convince those who are already convinced. And so only those who already think like the person who speaks about values agree. And everybody else thinks, how did he get to that point?
Well, one such individual I have with me over here is Sir Winston Churchill, who I wrote about and prepared a presentation on the European Convention on Human Rights. In fact, Professor, I must share, and I'm quite proud of this, his great-grandson wrote back to me and thanked me for presenting this. So I just wanted to share that. I now...
Oh, that's a good story.
Okay. Professor Martti, I just wanted to ask one question, taking Professor Popovski and Ankit's point forward. When we talk about state, the definition is restricted to Montevideo Convention. So in terms of sovereignty, property, or other aspects, because state is a very dynamic concept, so how do you see the concept of state evolving in the coming times? More than just the ruler or the authority or the government so-called representatives, but it's how does the non-governmental or the civil society members come into play into this whole definition in the coming times?
Well, a state is a little bit like those values. Nobody has ever seen a state. We have just seen people who say, well, I represent the state. And there is some usefulness in the institutions that states typically create. That is to say, government, legislation, etc. Even a small anarchist group, when the small anarchist group has made its anarchist rebellion, the first thing they have to do on the next morning after they have had the party, they will have to decide on who becomes the secretary and who becomes the chairman, etc. And that already is to think in terms of a state. A state is a form in which human beings relate to each other. It's a form in which those relationships are hierarchical and authoritative. They are not hierarchical and authoritative because people are bad, but because we need such relationships in order to be able to lead good lives. And then sometimes some of the people who get into hierarchical positions in those relationships then start to forget that they were there because of a common project, and they want to push forward their own project. And so this is a long response to your question. So I don't think the state is going anywhere in terms of a need for us to have these kinds of communities that are organized in institutions that have hierarchical relations and in which some people represent other people, some are able to make decisions, some are secretaries, etc. Civil society, well, that would be the people who are not now participating in precisely those institutions, but in other institutions. There's a huge amount of alternatives as to how we can imagine political society working. One of the great problems to which critical legal studies has always pointed, and which I've thought is one of the most important lessons from critical legal studies from my side, is that, well, people tend to think that the kinds of institutions that we have today are somehow necessary, and that precisely those forms have to be replicated in other places. We see in terms of reducing democracy, the idea of democracy into voting, for example. Why would we do that? Why? This is just, as Susan Marx would say, it's a light concept of democracy. We can imagine different kinds of democracies. In the same way, we can imagine the state in various different kinds. I think there's a necessity of imagining something like a state in the way I explained, institutions and hierarchical relationships. But we don't have to be fixated with that those should look like India or Finland or the United States or France. They could look like whatever.
Thank you so much. Thank you.
Now I think I would like to stop because I have another thing in 10 minutes time. So let me
thank you, Martti. It was wonderful.
Great privilege to have spoken with you.
Time. Thank you.
Thank
it
you
was
so much,
absolutely amazing.
Thank you
for sharing your time, your excellent comments. Your presentation is very well received. We really admire the way you talk, the way you put together, connect the concepts and make absolutely the best out of your time. Hopefully next time you can visit us and be in presence in our campus. We would like to invite you to come to us.
Okay,
and speak.
so okay, I'll hold you to that promise.
And we will arrange for the blackboard so that you can move around like you did in the Cambridge video, which I saw many times. Thank you so much,
Okay.
and good evening. Thank you.
Great. Thank you. Thanks everyone. Bye-bye.
Bye-bye.